please continue the
Thank you,
opening
Mr.
statement for the
President.
claimants. I may give you the news that you have 119 minutes left.
Thank you. I think that's good news. Thank you. Can you hear me okay with this microphone? I'd just like to check. Yes. Good. That's good. That's good. Thank you. I will do so. I'll try. So I will take you through the events of March to August 2011. And as you all know already, the events were triggered by the Fukushima accident on 11th of March 2011. As we have explained in our submissions and through the evidence presented, the Fukushima accident was a man-made accident. It was a result of a failure on the part of the regulatory bodies and the operator to implement the most basic safety requirements and standards for the well-known risks of tsunamis in the area close to Fukushima. And this was a disaster made in Japan. These were some of the conclusions reached by the independent committee which later were to review the Fukushima accident on behalf of the Japanese government. The Commission gave a list of recommendations for the Japanese government to consider. However, the Commission did not suggest abandoning nuclear power or adopting a different safety philosophy in Japan. As we have explained in our submissions, German nuclear power plants meet a considerably higher safety standard, and are located obviously in an area with no risk of the natural hazards that we saw in Japan. Now, Germany's actions following the Fukushima accident, which I will come to in a moment, need to be considered in light of the political landscape in Germany at the time. In the autumn of 2010, while the negotiations for the Development Fund Agreement and the lifetime extension were ongoing between the government on the one hand and the nuclear power plant operators on the other, as Dr. Hab mentioned earlier, the governing coalition consisting of the CDU, CSU and the FDP was losing support and were far from obtaining a majority in the Bundestag according to the polls. And the Greens, which had strongly opposed the lifetime extension, had a support of 20% according to the polls. Now, looking onwards, in the spring of 2011 there were to be parliamentary elections in 4 Länder or states in Germany. One of those was Baden-Württemberg, where 4 of Germany's 70 nuclear power plants are located. And the Länder elections were also important at the federal level, since the outcome would affect the distribution of seats in the Bundesrat, the second chamber of parliament. And in terms of upcoming elections, it is important in this respect also to bear in mind that in March 2012 there were to be elections in Schleswig-Holstein. And of course, if we look at the timeline here, and as explained by Dr. Happ, this election would be held only a few months after the scheduled restart of Krümmel in January 2012. Now, so we'll now go on to explain the Fukushima accident would come to have an enormous impact on the political scene in Germany, and ultimately, and unfortunately for claimants, nuclear power plants. And we will start on the day after the Fukushima accident on 12th of March, where Federal Chancellor Merkel held a press conference and where she said and confirmed that the nuclear power plants in Germany are perfectly safe and that Germany is not threatened by the earthquakes or tsunamis of the type that we saw in Japan. Now, on this very same day, 12th of March, there were large demonstrations in Baden-Württemberg, and SPD and the Greens took advantage of this public mood and was advocating that Germany exit nuclear power as soon as possible, and also therefore abolish the lifetime extension which had been granted just a few months earlier. And among political commentators in Germany at the time, there seemed to be a general consensus that the Fukushima accident was very likely to influence the upcoming elections. Now, on 13th of March, Federal Chancellor Merkel appeared on TV, and she once again confirmed that the nuclear power plants in Germany were safe. And she also said the following: I believe that you should not merely look at the actual age, now speaking about, of course, the nuclear power plants, but you should also consider what has happened within the reactor. And to a large extent, they have also been developed further and retrofitted. I can't now give a list for every individual nuclear power plant, but what is important to me, and that is always being counter-checked with the highest level of safety requirements, that is that we can say our nuclear power plants are safe according to current findings. 2 days later, on 15th of March, Federal Chancellor Merkel met with the Minister President of the Länder which host nuclear power plants. And during this meeting it was decided to temporarily shut down all 7 old nuclear power plants as part of what became known as the Moratorium. And this decision was then obviously taken despite the fact that the government repeatedly, and as we have seen now just 2 days before, had confirmed that the plants were safe. And no explanation was given why the old nuclear power plants, which had been a couple of months earlier been considered safe enough to be given a life extension, had to be shut down for a safety review, whilst the new nuclear power plants can continue to operate whilst undergoing the same review. Another 2 days later, 17th of March, the Federal Ministry for the Environment instructed the Reactor Safety Commission to conduct a comprehensive safety review of all German nuclear power plants in light of the Fukushima accident. And the deadline was set for 15th of May, so I will come back to the report later on. On 18th of March, the Office for Reactor Safety and Radiation Protection of the Ministry of Justice of Schleswig-Holstein produced a briefing paper to prepare Minister President Carstensen of Schleswig-Holstein for an upcoming meeting with Federal Chancellor Merkel. And this is Claimant's Exhibit 111, and I think Professor Holber also mentioned this document during his introductory remarks. As we can see at the heading, one of the purposes behind this of this very document was to conduct a comprehensive legal assessment of the question of how and or under what conditions restarting the nuclear power plants of Brunsbüttel and Krümmel can be prevented. So there's no doubt that the ambition of this very document was to try and find ways to shut down claimants' power plants Brunsbüttel and Krümmel. Now, in the briefing paper, Schleswig-Holstein stated it was highly likely that the moratorium was lawful, and it was also stated that no legal means existed to stop the nuclear power plant operators from resuming operation. Also, other authorities came to the same conclusion at this time, and we have submitted other documents which I will not take you to, but let me just mention them for the record: Claimant's Exhibit 106, Claimant's Exhibit 122, and Claimant's Exhibit 118. They're all documents from various authorities in Germany questioning the legality of the moratorium. Now, the legality of the moratorium is not being challenged in these proceedings. However, the fact that the German authorities were questioning its legality, and that the federal government in Schleswig-Holstein nevertheless decided to press ahead with the moratorium, and ultimately also to press ahead with the permanent shutdown of claimants' nuclear power plants, show that nothing was allowed to stop the political process that had now started to accelerate the phase-out and permanently shut down claimants' plants. Now, in the briefing paper that we have just looked at, which is still on the screen, It was also emphasized that the Krümmel plant should be included among the plants that were to be shut down during the moratorium. Let me take you to another passage of this document, which is on page 3. Here there was a discussion as follows, and I will read part of this to you. In summary, it should be noted that based on applicable law and the licensing situation, it will not be possible to reject consent to restart if the factual requirements are satisfied. This is in line with what Dr. Happ mentioned earlier. However, the following options under which a restart of the Brunsbüttel and Krümmel installations would no longer be possible may be subject to consideration. So here they were trying to find ways to permanently shut down claimants' plants. There were 3 basic options. The first one was to try to reach an agreement with the operators. That's the first option. Second option was to see if there were any licensing requirements that were not satisfied. And thirdly, there was the route which was ultimately adopted, which was to amend the Atomic Energy Act. And here you have another passage from the very same memorandum, where it is stated that it is imperative that the issue of whether the Krümmel nuclear power plant should also be included in the moratorium be clarified. Minister President Carstensen has been advocating vehemently that this reactor should not be allowed to be reconnected to the grid. Satisfying this demand would certainly be more difficult if it was determined that such a 3-month safety review was not necessary in Krümmel. So, as we can see from this document and many other documents that have been submitted as evidence in this case, the government of Schleswig-Holstein and authorities of Schleswig-Holstein took immediate action to try to shut down claimants' nuclear power plants. There was, generally speaking, a lot of activity within the State Chancellery of Schleswig-Holstein at the time. And moving on 22nd of March, the federal government established an entirely new body, the Ethics Commission. And the members of the Ethics Commission were appointed by Federal Chancellor Merkel. It was co-chaired by Klaus Töpfer, who is an outspoken opponent of nuclear energy. And none of the members of the Ethics Commission had any experience of nuclear energy. Now, the task of this body was to evaluate the risks of nuclear energy for the society at large. The task of the Commission was not, we say, to freely deliberate and advise the government, but merely to legitimize a decision which basically already had been taken. And this was actually confirmed by one of the members of the Ethics Commission, Professor Renn, who delivered a speech on 6th of March, which we have submitted on the record as Claimants Exhibit 127. And on pages 5 to 6, Professor Renn said as follows: the task of the Ethics Commission was the legitimization, therefore a substantiation of the energy policy change in such a form that those who probably are still skeptical about this new policy can support it with conviction and in a trustworthy manner, internally and externally. The Ethics Commission has also been reproached for that. How can scientists become willing to contribute to the legitimization of politics? Meanwhile, Schleswig-Holstein and in particular Minister President Carstensen continued the campaign against the restart of Krümmel and Brunsbüttel. On 23rd of March, in the session of the Schleswig-Holstein Parliament, Mr. Carsten emphasized the importance of shutting down Krümmel and Brunsbüttel. However, it was equally clear at this time that there were no legal possibilities to prevent a restart of Krümmel, as the law then existed. And Mr. Carstensen also acknowledged as much on TV on 3rd of April. This is Claimants Exhibit 112. I will not take you to that document now. And therefore a law was needed, or an amendment to the existing Atomic Energy Act, and that was confirmed by the Federal Ministry of Justice in a memo that we have submitted as Claimants Exhibit 133. I will not take you to that document either, in the interest of time. Now moving on 4th of April, the Deputy Minister for the Environment, Mr. Becker, confirmed that it had already been decided to shut down not only the old nuclear power plants but also Krümmel, and we are now talking about a permanent shutdown. This is Claimants Exhibit 136. Now, as the second in command of the ministry, which was responsible for nuclear safety in Germany, there can be no doubt that Mr. Becker was well informed about the developments at the time, and that his statement correctly reflects what was happening at the time. Which means that if we look at the timeline, we're now in the beginning of April. So 6 weeks before the Reactor Safety Commission was due to render its report, about 8 weeks before the Ethics Commission was due to render its report, it seemed that a decision had already been taken to permanently shut down the old nuclear power plants, and that included, of course, claimants' power plant Brunsbüttel, and Krümmel as the other nuclear power plant to be permanently shut down. At a press conference on 15th of April, directly after a meeting with Mr. Carstensen discussing the scope and extent of the shutdown, Federal Chancellor Merkel spoke about amending the Atomic Energy Act, not only in respect of the 7 old nuclear power plants, but also in relation to Krümmel. However, once again, no explanation was given as to why the Krümmel plant should be assessed together with the old nuclear power plants, which of course was in clear contrast to what had been the situation just a few months earlier in relation to the lifetime extension. If we then move into May, on 12th of May, the heads of the departments from certain federal ministries met at the request of the government. And during the meeting, the Atomkonsens was discussed, and this is what was recorded at the time. This is the minutes of meeting of federal ministries submitted as Claimants Exhibit 145. And it says as follows: the Federal Ministry of Economics and Technology then raised concerns that the agreement from 2000, and that is the Atomkonsens, had also contained other aspects, such as the promise that the safety philosophy would not be changed, and the economic framework conditions would not deteriorate to the detriment of the energy supply companies. A change of system to specific deadlines might also already cause problems under constitutional law. The option of transfer of electricity volumes and taking account of any standstill times have been a not insubstantial part of the agreement reached at that time. The additional volumes granted by the legislature in 2010, which is the lifetime extension obviously, might need to be included in a review under constitutional law. So those were the concerns raised at the time. And at this very meeting, there was also an agreement reached to now introduce fixed shutdown dates for the power plants. Now, following this meeting, the Federal Ministry of Justice prepared a memorandum to the Federal Ministry of the Interior addressing the possible consequences of the discussions and the agreements reached at the meeting that we now have looked at on 12th of May. So let's look at that memorandum, which is from 16th of May. This is Claimants Exhibit 147. And I will take you to one aspect of this document, which concerns the establishment of early fixed dates, which I said before was agreed upon at the meeting on 12th of May. And there are 4 bullet points here. I will take you to the first 3 of those. So this sets out the consequences of the establishment of early fixed dates according to the Federal Ministry of Justice at the time. So this is contemporaneous documents. First bullet point, where they make it clear that the residual electricity volumes calculated during the 2002 nuclear phase-out, which then, of course, are the OEPV that we have talked about, will not be able to be generated in their entirety. Second bullet point, the NEPV mentioned in that bullet point will certainly not be able to be generated. And then in the third bullet point, there was a discussion about the possibility to transfer or sell the residual electricity volumes of one nuclear power plant to another. That, in the view of the contemporaneous view of the Federal Ministry of Justice, was that they lose their economic meaning because the fixed final dates lead to a situation where a nuclear power plant can no longer affect an extension of power operation by purchasing residual electricity volumes. So at this time, it's clear that Germany knew that the proposal, or the decision rather, that basically had been taken to permanently shut down claimants' nuclear power plants to establish fixed shutdown dates would have severe negative consequences for the nuclear power plant operators, including claimants. And it should be mentioned also in this context that the Federal Ministry of Justice, in fact already 1 month earlier, had stated that the inclusion of Krümmel among the plans to be immediately shut down raised serious concerns from a legal perspective. I will not take you to that document, but that is a document submitted in this arbitration as Claimants Exhibit 224. Now, unfortunately, particularly for claimants, the concerns of the Federal Ministry of Justice expressed both in May, that we looked at, and April, in the document that I just referred you to, they were not taken on board. Instead, political considerations were allowed to continue to drive and consume the political process also going forward. Now, on 16th of May, the same day, the Reactor Safety Commission rendered its report. And that has been submitted in this arbitration as Claimants Exhibit 27. And basically, the Reactor Safety Commission concluded that there is no risk of the type of accidents that we saw in Fukushima, and the Commission also confirmed the safety and robustness of German nuclear power plants. One of the main conclusions of the report was also, as you can see on the second line here, that there's no general result for all plants and they are not dependent on type, age of the plant and generation. This is of course an issue which also Dr. Happ mentioned before. And in an internal memorandum, a couple of days after the Reactor Safety Commission had rendered its report, the Federal Ministry of Economics, we believe, because this is a document we received from the Federal Ministry of Economics, it was acknowledged that the Reactor Safety Commission's report provided no support for the plans to shut down the old nuclear power plants and Krümmel. Let us look at the central findings of that report. There were four central findings. Sorry, there were 5, but I will take you to 3 of them. The first one is that the Reactor Safety Commission reaches a conclusion that a comparable event cannot occur in Germany. No new state of knowledge in terms of the safety of the German plants can be derived from the report. On the contrary, with regard to the accident at the Japanese Fukushima nuclear power plant, it is evident that the German nuclear power plants exhibit higher safety reserves in terms of natural events, and also that the electricity supply is more robust throughout, and that these therefore clearly exceed the statutory requirements. Another and very important point was the following. the report contradicts the widely disseminated theory that older reactors are fundamentally less well designed than newer plants in terms of their susceptibility to breakdown. The retrofitting that has taken place since they were commissioned has in some cases led to high levels of robustness, and against some criteria they are even higher than those of the newer plants. So as we can see, the Federal Ministry of Economics took no issue with the findings of the Reactor Safety Commission, but rather confirmed that the German nuclear power plants were safe, and that safety is not dependent on the age or type of reactor in question. And this conclusion rules out the validity of Germany's argument that Krümel rightfully was shut down because it was part of the 69 construction line. On 17th of May, a meeting was held between the federal ministries involved in the preparation of a phase-out of nuclear energy, and in complete disregard of the findings of the Reactor Safety Commission, a decision was taken to proceed to shut down the old nuclear power plants in Krümel. That's Claimants Exhibit 149. So it seems clear that little, if any, attention was given to the report of the Reactor Safety Commission. And this has also been confirmed later on by no other than the Federal Chancellor Angela Merkel during her testimony before the Hesse Investigation Committee. We have submitted this on the record, and I will take you now to two passages in her testimony. Now we have two translations of this document on the record, Mr. President. For the purpose of this opening, I will simply adopt the translation provided by respondent. So this is Respondent Exhibit 285. So we will start on page 45 and 46, where Angela Merkel was being questioned by Mr. Norbert Schmidt, and the discussion was as follows. I would nevertheless like to address the question of the legal classification. Were you surprised about the findings of the Reactor Safety Commission that determined that a distinction based on construction type, age, generation was not possible, that no safety differences could be perceived? Were you surprised when, I think it was in May or in June, you were able to take notice of the findings of the Reactor Safety Commission? I can't remember taking notice of them. I cannot exclude the possibility that I saw them, but I can't remember now. Well, okay. But what...
Could you, for the records,
who is saying
identify
what?
who said what?
Yes, of
This
course.
was Dr. Merkel who said this.
Yes. So the question was posed by Norbert Schmidt. Then I can't remember until, but I can't remember now, was said by Dr. Merkel, and now it is Mr. Schmidt again who asked the question. Well, okay. But wasn't that an important procedure, Chancellor? The decision of the specialist committee that I have been commissioned with examining which consequences can be drawn, which problems result from the terrible events in Japan for Germany. With all due respect, I'm surprised that you say you don't remember anymore. I don't remember. I
don't remember, that's Dr. Merkel saying.
Yeah, sorry. I forgot. I don't remember either. So this is now Dr. Merkel continuing. I only remember that at the time matters were advancing. We had set up the commission chaired by Mr. Töpfer. We had started conducting political discussions. All parties agreed on the entire changed nuclear phase-out scenario. The time frame of the moratorium had almost come to its end, and we were already one step further. I believe we already drafted the bills in June, but I don't exactly remember that now. Everything happened very quickly and very unanimously. So let me take you to another passage from this testimony. And this is now Janine Wissler, who is asking questions to Federal Chancellor Merkel. So Ms. Wissler asked the following. In response to a question posed by our colleague Schmidt, you said that you cannot remember having taken notice of the results of the Reactor Safety Commission. Was that correct? And Dr. Merkel said, I cannot remember that. Yes. Ms. Wissler, but if one prepares a 3-month moratorium with the objective of the safety review, I would assume that one would be very cautious, or curious rather, to find out the results of this safety review, which, let's say, was the prevailing aim of the moratorium, and that one would have a close look at it in order to draw political conclusions from it. And the answer from Dr. Merkel was, well, by then we already had drawn the next political conclusions from the results of the Commission. Next question from Ms. Whistler. Excuse me, the Ethics Commission? Dr. Merkel, yes, the Ethics Commission. I think the Reactor Safety Commission was only, what did you say, in May? Another question from Ms. Whistler. In May, on 16th of May, the report was provided. Dr. Merkel, by then we were already in the final phase of the work of the Töpfer Commission, and for the record, the Töpfer Commission is of course the Ethics Commission. And we then opted for new lifetimes by way of a broad political consensus. So it is obvious that no real attention was given to the Reactor Safety Commission here. Now, during its deliberations about the intended phase-out, the government consulted with numerous parties, but never with claimants. We have said quite a lot about that in our submissions. I will not take you to that now. We would just like to take the tribunal to one event in this respect when it comes to the consultation, which is in fact relevant for something else, and that is in relation to a briefing paper, once again prepared for, I should say, the Federal Minister for Economics in view of an upcoming meeting with the CEO of E.ON, Dr. Tyson. And this was a briefing paper dated 26th of May 2011. This has been submitted as Claimants Exhibit 155. And there is an interesting passage when it comes to the description of Krümmel in this document. It says that Krümmel is one of the newer MPPs, started operating in 1984. It has residual electricity volumes, enough to see this major nuclear power plant continue operating at least until 2019. And then it goes on to say, and this of course confirms what Dr. Happ mentioned earlier, that with trust placed in the legal situation, considerable investments have been made in the last few years to keep this plant operating. On 30th of May, the Ethics Commission submitted its report, and since the real aim of the Ethics Commission was to legitimize a decision which basically had already been taken, to revoke the lifetime extension and to implement an accelerated phase-out, it is not surprising that the Ethics Commission came to the conclusion that it did. Now, Germany has in this arbitration refused to disclose the meeting minutes of the Ethics Commissions. We are not privy to what was specifically discussed. However, it is clear from the report that the view of the Ethics Commission was that the perception of risk, which Professor Hober emphasized during his introductory remarks, that the perception of risk and the perception of safety of the general public should play an important role. So this is an extract from the Ethics Commission's report, Claimants Exhibit 125. And here we see that the Ethics Commission said that the risks of nuclear energy have not changed since Fukushima. So that, of course, confirms our position when it comes to safety. But the perception of risk has. And as we said before, there was no reason from a technical or safety perspective, in no way whatsoever, to shut down claimants' nuclear power plants. It was based on a perception of the public perception, basically. And this is basically what this case is about. For no objective reason whatsoever, instead based on what was perceived to be the public's perception at the time, Germany proceeded to implement the 13th Amendment. Now, on the very same day that the Ethics Commission published its final report, and in complete disregard of the findings of the Reactor Safety Commission, the governing coalition agreed on a revised energy strategy. And that included that the 7 old nuclear power plants and Krümmel were to be permanently and immediately shut down, and that fixed end dates were introduced for the remaining power plants. And this is something, of course, that hit Brockdorf, the 3rd nuclear power plant relevant for these proceedings. There's another interesting passage in the Ethics Commission that I would like to take you to, and that relates to page 6, where the Ethics Commission said that for the economy and society, planning reliability is a valuable asset. It has a large stake in competitiveness and also plays a central role when calculating the profitability of investments. Now, that is, of course, very much true. Claimants agree that planning reliability is a valuable asset. Planning reliability have been provided to the operators through the Atomkonsens, the lifetime extension and the development fund agreement, which were all negotiated with the nuclear power plant operators. However, in 2011, Germany changed its energy policy almost overnight. And this was in clear contrast to the planning reliability that had been provided, as I said, through the lifetime extension and the Atomkonsens. As we have seen in the documents, as we have mentioned earlier today, the accelerated nuclear phase-out that the federal government was determined to implement needed to be enacted into law. There was no other way of doing it. But the issue was one of great magnitude. We're talking about the abrupt reversal of the energy policy of Europe's largest economy. And despite its importance and significance, the 13th Amendment was pushed through Parliament in an extremely limited period of time. And during the time the 13th Amendment was being processed through Parliament, Schleswig-Holstein took credit for having been able to close down the claimant's plants on a permanent basis. And we can see that, among other, there are many examples of this, but one example is in Claimant's Exhibit 174, where Minister President Carstensen, in a session in the Landtag of Schleswig-Holstein, said the following: "This is why, on 23rd of March, I stated that after the moratorium, we must not simply let everything go back to normal. The lifespans of German nuclear power plants must be shortened. We keep our word. The 7 oldest nuclear power plants, as well as the Krümmel nuclear power plant, will remain permanently shut down." Now, Germany suggests that the 13th Amendment really had no impact on claimants, since it was a mere return to the Atomkonsens with only minor modifications. As we have explained in our submissions, this is completely wrong. Point 1, under the Atomkonsens and the 2002 Amendment, claimants were promised undisturbed operation until their electricity production volumes had been exhausted, and this right was abolished by the 13th Amendment. Second point, the Atomkonsens and the 2002 Amendment granted a right to the nuclear power plant operators to sell electricity production volumes. And because of the 13th Amendment and the resulting destruction of the market, claimants can no longer make any such sale or transfer, just as the Federal Ministry of Justice correctly had predicted in the document we just looked at in March 2011. Therefore, also this right was effectively taken away from claimants. And Germany's contention that the 13th Amendment merely is a return to the Atomkonsens is clearly without merit. I will leave you with those remarks and hand you over to Mr. Andersson, who will take you through some of the legal arguments in the case. Thank you.
Any questions?
Can you hear me if I stand up? It's yeah, I know. Maybe I'm too tall for the machine. Let me know then and I'll sit down. I'm just used to standing up. Okay. Right, so I will continue now and summarize the legal arguments on liability. And yes, okay. Claimant's case rests on two main legal grounds. Claimants argue, firstly, that Germany has expropriated claimants' investments in violation of Article 13.1. And the second argument is that claimant has breached Article 10.1 of the ECT. As Professor Holbeer pointed out, these are claims under the ECT. They should be determined under the ECT in accordance with international law. Now, German law has little role to play in this arbitration. It's relevant only as part of the facial matrix. It is not applicable to determine whether a certain right or a property is an investment under the ECT, for example. Starting with the expropriation claim. As the tribunal knows, Article 13.1 provides protection against expropriation. It protects both direct and indirect expropriation. It's a straightforward expropriation claim, provision. The parties are agree, as far as I understand it, that it is the effect of the measure that determines whether an expropriation has occurred. And Germany has confirmed that it does not invoke the police power doctrine in support of its defense. So that's the point of departure for the tribunal's assessment of the expropriation claim. As you have heard, by adopting the 13th Amendment, Germany revoked the new volumes. We call them the NEPV. Germany revoked Krimel's operating license, and Germany rendered the old volumes worthless. These are the three components of claimant's expropriation claim, and I will comment on each of them in turn. The first step in the assessment of the expropriation claim of the NEPV, the new volumes, is to assess whether these are investments under Article 1.6 of the ECT. And as the tribunal knows, the Article 1.6 provides a very broad definition of investments. It covers every kind of asset, any right conferred by law or contract. It protects investments owned or controlled direct or indirectly. The new volumes are rights to produce electricity. They were agreed as part of the Development Fund Agreement, and they were later incorporated into the 11th Amendment. And in the explanatory note to the 11th Amendment, these new volumes were described as set forth in the second bullet point on the PowerPoint presentation. The rights for the generation of electricity volumes will be expanded by volume, which makes it possible to operate the nuclear power plants for an average of an additional 12 years spread over all nuclear power plants. This is how the granting of those volumes were described in the legislation. The legislation then sets forth specific tables where the volumes are allocated to specific plants, including then claimants' plants. These rights, as been pointed out, could be sold. They were transferable rights. We submit that these are indeed assets belonging to claimants, qualifying as investments under Article 1.6. these assets were revoked without compensation, and we submit that that amounts to a direct expropriation. I'm moving on to the operating license for the criminal plants. Here we say it's clear that an operating license for a nuclear power plant is indeed an asset qualifying as an investment under Article 1.6 of the ECT. The license was revoked without compensation, and hence we argue that we have a direct expropriation here as well. The third component of the expropriation claim is the old volumes. These are the production rights that as you have already heard, that was granted to claimants and the other operators as part of the Atom Consents and the 2002 amendment. These were transferable volumes, they could be sold, and they included no time limitation. Claimants could produce these volumes in their own plants without restriction to time, or they could sell them to other plants for profit. We argue that these rights as well qualify as investments under Article 1.6 of the ECT, these volumes. And here we say, we still have title to these volumes, but here we say that these volumes were indirectly expropriated by the 13th Amendment. The 13th Amendment shut down claimants' nuclear power plants, so we couldn't produce these volumes ourselves. It also shut down a number of other power plants, created an oversupply of volumes, so the demand for volumes disappeared. And it introduced the fixed end dates. It set an end date for where any sale of volumes had to be carried out, after which the volumes became worthless. Now this combination rendered these volumes worthless to claimants. It's not in dispute that there is no interest in these volumes today. It hasn't been any interest or demand for these volumes since the 13th Amendment in 2011. And claimants argue, or Germany argue, that in 2019 it should be possible, or 2020, to sell these volumes. Fact is that the volumes have no value today. They are worthless. And that...
Mr. Anderson, may I ask a question here on this?
Yeah, sure.
Obviously you will explore that with the experts and the witnesses, the OEPV, that they have become worthless. But the other point is this, what the valuation date?
Sorry?
Your valuation date for the expropriation
Yeah.
is, I think, 11 March 2011, is that correct?
True.
The event for the expropriation is what, according to your submission?
The event for the expropriation.
Which caused the expropriation? Was it the 13th Amendment?
It was the 13th Amendment, yes.
So that is a few months later, isn't it?
Yes.
So if you look to the compensation requirement under Article 13.1, which says that you have to value, the valuation date is the time immediately before the expropriation. What do you understand to be immediately before the expropriation in this context?
Well, if I go back to 13.1 then, so they can...
So let's get the date clear. The 30th Amendment was adopted in, I think, the beginning of August, wasn't it?
Yes, it entered into force in the beginning of August. Then Mr. Kasmarek has chosen the March as the valuation date, because and he will have to explain that himself, because following Fukushima in March, that's when the effect of the expropriation became known. So that's why it's a difference between the enactment of the law and the valuation date.
I see.
Okay. Sorry? Yeah, you want to add something, Dr. Rapp?
Mr. President, to add, you have correctly cited that the Energy Charter Treaty says that normally the valuation date is the day immediately before the expropriation became known. The concept which claimants have pursued in their briefs, and which I think our expert also has used, is the following. The very idea and purpose is behind this, the day before the expropriation, is to have an valuation undisturbed, uninfluenced from the upcoming expropriation. And our position is that since the date of the moratorium at the latest, if not even since the day of Fukushima, it was not possible to have an uninfluenced value of the power plant. So that is why the valuation date was also why the expert moved back. It is, I think Mr. Katzmer can that explain, a rather complicated procedure of discounting and upcounting. We say that the date is the 13th Amendment, but we say that the only date at which evaluation uninfluenced by Fukushima and its consequences was possible was the 11th March, and we think this is in full compliance with what the Energy Charter Treaty says.
The question here is what is the measure?
The measure is the 13th Amendment.
Yeah, and then you go almost half a year back for the valuation date.
Yes.
I think we need to keep in mind that the moratorium was announced on the 15th of March. So this is the day before the announcement of the moratorium. That's why the 14th of March is used as a valuation date by Mr. Kaczmarek. With respect to certain prices, it's the 11th of March.
Would it then not be that the moratorium is the measure in your submission?
No.
It is not, but I raised the question whether you could be viewed differently.
Yes, well, we are not challenging the moratorium. We're not relying on that as the measure. But okay. So we say that the combination of the 13th Amendment, the effects that legislation had on the old volumes, amounts to a substantial deprivation of the value, use and enjoyment of the investments. And while I'm on this point, I cannot avoid making one slight digression, an observation on Germany's position when it comes to the old volumes. On quantum, Germany argues that these old volumes are very valuable assets. They could be sold for almost €1 billion in 2019, 2020. However, on liability, the position is that these volumes are not even rights protected by German law. They are not even capable of being expropriated at all. And this implies that these volumes could be taken away tomorrow without any consequences. And that is quite an inconsistency compared to their position on quantum, which could be borne in mind by the tribunal when you listen to Germany on quantum. So, in conclusion, on expropriation, it's our case that the new volumes have been expropriated, that the operating license for criminal plant has been expropriated, and that the old volumes have been expropriated. So I'm moving on to claimant's claim under Article 10.1. Here we have initiated a number of different claims. We argue that Germany has breached the umbrella clause in Article 10.1. We also argue that Germany has failed to accord fair and equal treatment, and that Germany has failed to refrain from unreasonable and discriminatory measures, and that Germany has failed to offer most constant protection and security. I will not spend time on point 3 and 4, but I will comment on the first 2 points. And I will start with the umbrella clause claim. And I will briefly then reiterate the facts that we rely upon here. Now, under the Atomkonsens, claimants accepted the structural phase-out and a lifetime limitation. Before the Atom Consents, there were no lifetime limitation at all on nuclear power plants in Germany. And claimants abstained from raising claims in court at that time, challenging the phase-out. In consideration, the German government made a number of commitments. It granted the old volumes, unlimited in time. It promised undisturbed operation. It promised not to change the underlying safety philosophy. And it promised not to discriminate against the use of nuclear energy, including taxes. That was the deal. All of these commitments were breached by the 13th Amendment and the introduction of the nuclear fuel tax. So we say that it's clear that Germany has breached the umbrella clause. Okay. So the objection here is that the Atom Consents is not binding. That is what Germany is arguing. This agreement that was negotiated for years, that was signed by the very highest officials in Germany, including the Federal Chancellor, that induced claimants and the other operators to abstain from challenging the phase-out in court, that has been relied upon for a decade for substantial investments. This is merely a non-binding political declaration. That is Germany's case. We cannot accept that position. Firstly, we submit that Germany cannot now invoke German constitutional law to avoid these clear commitments that it made in the Atom Consents. It's just to read the agreement. There are commitments in that agreement. We argue that Germany has an independent obligation under international law, which is enforceable under the umbrella clause. And alternatively, we argue, we disagree that the Atom Consents does not create obligations under German law, and we have submitted evidence to show that that is the case indeed, and I refer to Professor Kischel's expert report, and we will hear him later on this week as well. And this leads us to the conclusion that Germany has reached the umbrella clause claim. Umbrella clause, sorry. So moving on then to the fair and equitable treatment claim. I will briefly describe the different components of claimants' fair and equitable treatment claim. First, I would like to make 3 general observations. Claimants do not dispute, as Professor Beer pointed out, Germany's right to regulate its domestic affairs. We accept that Germany has such a right. However, a state exercising its regulatory powers must comply with the rule of law and its international treaty obligations. This case is about whether Germany has complied with its obligation under the ECT to provide fair and equitable treatment. That is what the tribunal should assess and determine. Second point, the FET standard under the ECT is not equal to the minimum standard of treatment under customary international law, as Germany argues. It's generally accepted, I would say, that FET standards, unless there is any support in the treaty itself, included in treaties, bilateral investment treaties and multilateral investment treaties, cannot be diminished to the customary international minimum standard of treatment. This is particularly true, I would say, for the FET standard in the ECT, which has a special focus on long-term investments in the energy sector, and it's a treaty with a special purpose and a particular wording. Third point, the FET standard under the ECT is not qualified by any margin of appreciation, as argued by Germany. First point here is there is no support in the wording of the treaty for implying a special exception into the FET standard of the sort suggested by Germany. Had the drafters intended for such a margin of appreciation to be part of the FET standard, it could have been reflected in the text. It's not. On the contrary, the wording and the structure of the ECT suggests that that was not the intention of the drafters. And I note in this respect Article 24 in the ECT, which deals with exceptions. Now it follows from that article that also measures that are deemed necessary for the protection of human, animal and plant life must comply with Part 3 of the ECT and the expropriation provision in Article 13. This reflects the focus of the drafters, the focus they had on investment protection. I would say that with that structure it would be incorrect to interpret the ECT to include an implicit reference of a margin of appreciation in Article 10.1. So in conclusion, what the tribunal should try in our view is whether the treatment of claimant was fair and equitable under the ECT without adding any additional qualifications or exceptions that does not belong in the ECT. So I will then turn to the four components of claimant's fair and equitable treatment claim, and I will start with stable legal framework or stability. It's our position that the fair and equitable treatment standard includes an obligation on the host state to ensure a certain level of stability in the legal framework. And I would say that this is particularly so when it comes to the ECT, which has a special focus on stability. It deals with investments in the energy sector, long-term investments. And the opening sentence, the first sentence in Article 10.1 emphasizes this, the commitment to provide a stable, transparent and favorable conditions. And then the second sentence ties into the first sentence when it says that such conditions shall include fair and equitable treatment. So there's a link there that should be kept in mind. Now here claimants say that there was stability here. It was agreed as part of the Atom Consents and the 2002 amendment. German government and the operators, including claimants, negotiated a long-term structure for the phase-out. This was implemented into law, which sets forth long-term timetables with these volumes for how this phase-out was to be carried out. The 13th Amendment, contrasted to this framework that had been agreed and established, represents an abrupt policy U-turn. It's inconsistent with the Atom Consents. It's directly violating the terms of the Atom Consents. It's inconsistent with the 2002 amendment. It's inconsistent with the lifetime extension negotiated and agreed in 2010 and Germany's energy policy that stretched out to 2050. And it's inconsistent with the way the German government had handled all these discussions with the operators previously by negotiating. They sat down, negotiated for long term and found a long-term agreement. So we are not saying that Article 10.1 amounts to an absolute stabilization clause, or that the legal framework must be frozen. That's not our case. But a sudden and abrupt change like this, in violation of commitments made, for example, not to change the underlying safety philosophy in the Atom Consents, which destroys the investments for the purpose of satisfying a public perception, that amounts to a violation of the stability element in the fair and equitable treatment standard.
Professor Lowe has a question.
Yes?
Can I just ask you to clarify that point? When you said, if I can stop it, that a sudden and abrupt change like this in violation of commitments made not to change the underlying safety philosophy. And is it your case that a sudden and abrupt change would be a violation of the ECT whether or not it was a violation of a commitment made? Or are you saying that it is a violation of the ECT because the commitment is made? And another way of asking that question is to say whether the motive is relevant to anything other than the umbrella clause part of the claim.
Well, here we don't even actually need to specify a claim like that, but because we had commitments here that were violated. But if I understand your question correctly, you're asking whether we agree, if there were no commitment not to change the underlying safety, would we then argue that this was a breach? That's your question.
Yes.
Yes. Okay. Thank you. I believe that the answer would be yes, but that's not an uncomplicated question. So if I can come back on that.
And please do come back
Yeah.
to it, and there will be times throughout the next weeks when
Yeah.
this can be done. But it does go to one very large block of evidence, which is put out on the question of the safety justification. And I suppose another way of putting the question is, why does that matter? Why should a government not change its policy on the basis of what it understands a change of public perception to be? Now, your answer may well be that there are limitations on that, on the circumstances in which a government is entitled to change its policy. But it's that point that I'm not clear on.
Okay. We'll come back to you.
If I may add to that,
Yeah.
also when you talk about the sudden and abrupt change, in this case, unless I'm wrong, the sudden and abrupt change was not occasioned by something out of the blue air. It was occasioned by the Fukushima accident. To what extent does that legally play into this in the FET clause?
To what it change, to what extent the fact that the change was based on the Fukushima accident play into the...
Yeah. You say, well, look, you say well, the FET clause, fair equitable treatment clause,
Yeah.
Is not a stabilization clause, is not freezing the situation.
No.
But what we argue, this is what you're saying, is, what it is an abrupt change. What happened here?
Yeah.
But if this abrupt change is not so to be explained by a Fukushima accident relating to nuclear power, how would that then translate into the FET clause in the ECT, if at all, legally?
Yeah. Can I take that question on board as well? Because
Sure.
I'm
No,
not
okay, that's
to-
exactly so.
yeah.
It is a
Okay.
follow-up question of Professor Lowe.
It goes in the same thing. Okay, thank you. Right, that was stability. I'm moving on then to legitimate expectations. I think we agree that the parties that protection of investors' legitimate expectations is part of the fair and equitable treatment standard, and we may disagree on the application. We argue that the Atom Consents created legitimate expectations here. That agreement included specific representations, including granting of the volumes. We've been over this now, unlimited in time, undisturbed operation, unchanged safety philosophy. This agreement was then incorporated into law, and we submit that also the legal framework that followed as a result of the Atom Consents created legitimate expectations for claimants. And claimants relied on the agreement and the 2002 amendment, and Dr. Happ has explained how claimants did rely on that, on those measures. And claimants have invested on the basis of these, on the agreement and the 2002 amendment, huge sums of money into their plants. And I'll refer you to the witness statement evidence that I referred to in the PowerPoint presentation. The 13th Amendment frustrated those expectations, and we say that that amounts to breach of the fair and equitable treatment standard. Now, there is one argument that I would like to touch upon that has been raised by Germany when it comes to the expectations of claimants. Germany argues that claimants should have expected the 13th Amendment because it follows from the Kalka decision, rendered by the German Constitutional Court in the late 70s, that this is something that could happen. On that point, though, we disagree with that. First, what the Kalka decision says is that it confirms the acceptance of so-called residual risk. It's set out in that decision that risks pertaining to the use of nuclear power that go beyond practical reasons is a risk that must be borne by society as a whole. That is what the court is saying. Then the court says that the legislator may have a duty to examine the legal framework in case of new and unforeseen developments. That is basically the conclusions you can draw out of that case. It doesn't say the legislator must act. It may have a duty to examine the framework. It does not say anything about compensation or what the consequences could be in case of a change of legal environment. It's silent on that, so the rule of law applies. We submit that it does not follow from this decision that claimants should have expected that Germany could revoke production rights and shut down claimants' nuclear power plants in violation of commitments made without compensation, and where there is no safety reasons and where no examination had been carried out of the new developments, i.e. Fukushima. This decision was taken before even the first report on Fukushima had been published. Now this argument fails, we submit. Claimants could not have expected this treatment. Moving on to the third component of the fair and equitable treatment standard, and that's due process. Fair and equitable treatment requires that due process is observed. I think that should be undisputed in this case, and this means we submit that a host state must comply with some basic legal standards, reasonable advance notice, fair hearing, an opportunity for the affected party to voice its concerns, state its positions, so that the decision can be an informed decision. Now, one issue in this case is whether the due process requirement applies to a legislative procedure. That is, I think, the main objection from Germany. And we submit that it does. It should in this case. The 13th Amendment was a legislation that targeted specific plants and a limited number of private entities. And it very much affected claimants because all of their nuclear power plants were shut down. It's a legislative procedure with an administrative character. And in fact, as we have seen from the evidence, the legislative route was chosen to avoid an administrative procedure with the due process that would follow from that. Germany knew that they could not shut down the plants under the Atomic Energy Act. So we submit that in such circumstances, due process must be observed. And claimants were not heard. They were not invited to state their position at any time during the legislative procedure. It's not sufficient that other companies were heard or that a trade organization obtained a limited opportunity to voice their concerns. And it's certainly not sufficient that because claimants on their own initiative sent a letter to Germany that they were heard for that reason. That letter was answered only after the law had been adopted, and then Germany responded that there were no reasons for any complaints. That is not due process. Moving on then to the final component of the fair and equitable treatment, and then I'll be ready, and that's arbitrary conduct. We submit that to comply with this standard, decisions needs to be based on facts and legal standard and free from arbitrariness. And there's a lot to say about the procedure leading up to this law, but if we focus on the treatment of the criminal plant. Now, the criminal plant was licensed under the same regulatory requirements as the other plants that were allowed to continue operation. It had been defined as a new nuclear power plant together with these plants in 2010. That's just a few months before the 13th Amendment. No explanation has been provided for the new qualification and treatment of criminal. All of a sudden it was the 7 old nuclear plants and criminal. There's no explanation for what that happened, no official explanation. It's undisputed that there were no safety reasons for doing that. And claimants' contention, the evidence that we have submitted here about the effects of the political lobbying of the politicians in Schleswig-Holstein remains unanswered. There is no counter-evidence, no witness coming. So, what is Germany's response here? It's sweeping statements, to put it mildly. They say that the 13th Amendment was not arbitrary, it was a legitimate and careful considered response that had been rendered after objective examination of circumstances. And when I read this, I was looking for the footnote in the support, some evidence showing the objective examination, and it's not there. They also say that the 13th Amendment is consistent with certain considerations formulated after the event. It doesn't explain where the reasons were. Now we submit that the evidence leads us with the conclusion that the only basis for shutting down the criminal plant was political lobbying from the politicians in Schleswig-Holstein, and that we submit was arbitrary, an arbitrary decision. So, in conclusion, on liability, we submit Germany has expropriated the new volumes. Germany has expropriated the operating license for the criminal plant. Germany has forced claimants to try to sell the old volumes, and at the same time they have made that impossible because there is no longer any market, and that we submit is also an expropriation. Germany has breached the umbrella clause and the fair and equitable treatment standard, and for that Germany is liable. That concludes my presentation. I will now hand over to Professor Hubert, who will say a few more words on
One question of Professor Lowe.
Can I just add what is really a rider to my previous question for you to take into consideration over the next couple of weeks? And it is, are you saying that the selection of Krumel and putting it in with the other old plants is arbitrary?
Yes.
Or that the entirety of the 13th Amendment was arbitrary?
Well, I think we'll say both, but I'll come back on that one as well. Yeah.
Off the record, there was some discussion about whether the lunch could be kept warm. But I think we should conclude first the opening statement by the claimants. There is still
it will
now
take another 30 to 40 minutes, I think.
you have a human right, if I may call it that way, to lunch.
I mean, I don't know. As far as I'm concerned, I could break for lunch, I think.
No, I think it's better that you finish your presentation.
Okay.
If it's acceptable to everyone here in the room.
So how much time do I have, in fact?
44 minutes left.
Thank you very much. Well, I'm going to address some issues concerning quantum. And I will do it actually by addressing two categories of issues, if I may call it that. First of all, I will walk you through our prayers for relief and explain primarily our alternative prayers for relief. And that you will see eventually on the first slide I have. But the second thing I will do is to, again, with respect to each of the three plants, explain how the calculation of damages has been made. There has been some debate, perhaps, concerning, in this arbitration, concerning who is claiming for what, especially raised by the respondents. But just to make it absolutely clear that each claimant in this case, is claiming compensation for its own individual damages, nothing more, nothing less, and that is what I'm going to explain shortly. Our prayers for relief are set forth in paragraph 760 in our reply. I don't intend to take you there now, but I mean just for your reference. As you will see, the claims with respect to damages are found there in litera B and C, and those are the ones that I will focus on. We do have two declaratory reliefs, and I will mention the first one now, and that is a traditional declaration that Germany has breached its obligations towards claimants under Part 3 of the Energy Charter Treaty. But if you could take a look then at the first slide. Okay. Where we have summarized our claims. And in the right-hand column you see the total damages as per today, including pre-award interest based on LIBOR plus 4% compounded on an annual basis. The compounding is not expressly stated in our prayers for relief, but they are, I think, evident from the reports in Mr. Kazmarik's calculations.
Basically, at which intervals do you compound?
So annually.
Annually.
Yeah. Also, this raises the question that we discussed briefly this morning. These amounts do not include, does not take into account some of the minor adjustments that Mr. Kazmarik wanted to make and has identified since the date of this report, but we'll come back to that then after lunch. So the different alternatives you see on the slide are there to take account of Germany's objections on jurisdiction relating to those claimants who are incorporated in Germany and whether or not these claimants are controlled by Vattenfall AB. So if we take a look at step one, the first claim, and there you can see that Krümmel is claiming for its damages and Brunsbüttel is claiming for its damages, and Vattenfall Nuclear is claiming for its share in Bruckdorf, i.e. 20%. Now, if you agree with us on this, that's the end of the story, so to speak, as far as prayers for relief are concerned. At least as far as the structure of the claimants are concerned. I mean, any other variations to these amounts are just that, variations of the amounts and nothing else. If we move on then to step two, which is our first alternative claim, this claim we submit if you were to find that Krümmel is not controlled by Vattenfall, despite the fact that Vattenfall owns 50% of Krümmel and is the sole managing shareholder of it and holds the power to represent the entity. But if you nevertheless come to the conclusion that it's not controlled by Vattenfall, then we put forward this first preliminary claim, alternative claim, where Vattenfall then still claims for its 20% in relation to the Bruckdorf plant, but also for its 50% share in relation to the Krümmel plant. The next step, step three, is our second alternative claim then, and this comes into play in case you were to find that Vattenfall does not control Brunsbüttel, even though Vattenfall owns 66.7% of the company, of the shares, and is the sole managing shareholder and holds the power to represent the entity. In this scenario, the alternative claim is for the entire payment to be made to Vattenfall Nuclear, being the shareholder in Krümmel and Brunsbüttel. Vattenfall Nuclear then still claims for its 20% in relation to Bruckdorf, as well as for its 50% share in relation to the criminal plant, but also 66.7% of the shares in the Brunsbüttel plant. The third alternative claim, that's step number or item number 4 on the slide, is if you were to find that Vattenfall AB does not control Vattenfall Nuclear, despite the fact that it's a wholly owned subsidiary to Vattenfall AB. In that case, the entire payment that we're claiming for is to go to Vattenfall GmbH, i.e. the German subsidiary. And the amount, as you can see in step 3 there, is the same. No, sorry, in step 4, sorry, is the same as in step 3, although the payment is made to another entity. And the final alternative claim is item 5. And that's to take into account Germany's objection then that Vattenfall AB does not control Vattenfall GmbH. Then the amount claimed is basically the same as in item 4. I will come back to the small differences, but payment is to be made to Vattenfall AB. Now the differences between the amounts in item 4 and item 5 is basically the result of some tax adjustments that we don't need to get into now. I'm sure Mr. Kaczmarek is prepared to explain that later. But that's really the reason why there is a difference. So those are our claims, our prayers for relief, the primary claim and the alternative claims. As I said, we also have a second declaratory claim which relates to the Vattenfall AB claim. It is not unthinkable that the payments to be made to Vattenfall AB might be taxable also in Germany. I mean, they're taxable for sure in Sweden, but they might be taxable also in Germany. And for that reason, we have included in our prayers for relief a declaratory relief to the fact that if that were to happen, Vattenfall asks Germany to compensate Vattenfall for that tax payment. So those are the prayers for relief that we put forward, and as I said, you find them in paragraph 760 and to our reply, and also with the explanations there. So if I may then go on to talk about valuation and our calculations of damages with respect to the 3 plants. The reason why we have made 3 different calculations is perhaps obvious, but it's the 3 plants existed, so to speak, and operated under slightly different circumstances. So that's why we have made 3, or Mr. Kaczmarek has made 3 separate calculations. And in doing so, he has used and applied, as is customary, the discounted cash flow method to calculate the fair market value of claimants' investments in the but-for and the actual scenarios, as I mentioned, and the differences between these two obviously make out our claims for damages. Now, the valuation date that he has used is the 14th of March, which, as I said, is the day before the moratorium was announced. And we get that date by going back to Article 13.1 of the ECT, which speaks not only of the date immediately before the expropriation, but also the date of the impending expropriation when that became known in such a way as to affect the value of the investments. And if you look at Mr. Kazmarek's, I think it's first report, paragraph 10 on page 9, he explains that from an economic point of view, the 14th of March is the correct valuation date. Now, the 11th of March date that you mentioned, Mr. Chairman, I think is used by Mr. Kazmarek in doing some price projections. But the valuation date is the 14th of March. In light of some arguments that have been made by Germany, I think it's important to note in this context that what he has done is a comparison of actual values and values but for the measures, not but for Fukushima, as has been suggested by Germany from time to time. The Fukushima accident has in fact been taken into account by Mr. Kazmarek in making his calculations, both in the but-for and actual scenarios. The difference between the actual and but-for lies in the measures that Germany has taken. I mean, the immediate shutdown of the 7 old plants and the criminal plant, the revocation of the new volumes, the implementation of the nuclear fuel tax, the establishment of fixed shutdown dates, and so forth. That explains the difference between the but-for and the actual scenarios or values. Before turning to the actual plants, there is one aspect which should be mentioned, I think, and that is that the fair market value of a nuclear power plant is quite different from the value of most other assets, since it changes over the life of the plant. There are very large negative cash flows while the plant is being constructed, followed by a substantial positive cash flow while the plant is up and running and making money. Then finally, and this is the truly unique part for a nuclear power plant, at the end of the plant's operating life, it incurs decades of quite substantial negative cash flows as the plant is being decommissioned. And the nuclear waste is moved to final storage, as was briefly mentioned in the film we saw about criminal. For example, the
From what I read in your case here, this is in the form of provisioning every year.
Yes.
That it did.
Yes.
Okay.
I mean, the actual, I mean, you have provisions in the financial statements on an annual basis, but the actual cash outflows, of course, happens only when you de facto start to decommission. So, if we then move on to the first plant that I'm going to talk about, that's the criminal plant. But for the measures, criminal, and we start with the but-for scenario, but for the measures, criminal would have restarted operations in January 2012 and produced electricity by using its electricity production volumes, i.e. the OEPVs and the NEPVs. As you can see on the slide, there was no fixed end date for the operation of the plant, but criminal can be estimated to have run out of volumes, we say, in 2033. Thereafter, the plant would have been decommissioned, as I said, which would have included work and cost throughout 2093, i.e. for 60 years. On this slide, we have described in a rather generalized way how we, or how Mr. Kaczmarek has in fact calculated the value. I mean, you look at the total revenues, total costs, net income, and so on and so forth. So let me just go through these in a rather general way. Revenues in the but-for scenario would have come from the sale of electricity, obviously. These revenues we get by multiplying the volume of electricity generated, the megawatt hours, by the unit sales price of electricity, i.e. euro per hour. The annual electricity produced by Kreml we get by multiplying the electric power output, which in the case of Kreml was 1,346 megawatt, by the number of hours that the plant is expected to operate in each year. Mr. Kaczmarek has used an average effective utilization rate, as you can see, of 83%, which means roughly then about 7,300 operating hours per year. By multiplying those operating hours with the power output, we get an average power generated of approximately 10 terawatt hours per year. That's on the production side, so to speak. If we then go to the sales price of electricity, Mr. Kaczmarek has, for the first 6 years of his calculation, relied on German wholesale futures market prices. I mean, for base load electricity prices. These are reported on something called the European Electricity Exchange. He has had those prices available until 2017, and thereafter he has assumed that prices will be more or less constant in real terms, in other words, grow at inflation. Over the remaining operative lifetime then of Kreml, these factors combined, so to speak, would have resulted in total revenues of 13.8 billion. That's the income side. If we look at the cost side, we have listed the main costs, and these are operating expenses, depreciation, decommissioning, other costs, and taxes. And the largest group there, as you can see, are the operating expenses, which in turn fall into two further groups, namely maintenance costs and payments to the Renewable Energy Fund. As far as maintenance costs are concerned, Vattenfall has, as part of its budgeting process, prepared detailed forecasts of the costs that they would have incurred or should have incurred over the remaining operating life of the plant, and Mr. Kaczmarek has relied on those numbers when he's made his calculation. And the payments to Renewable Fund were then based on the Development Fund agreement that we've talked about previously. Depreciation is another major cost item, includes depreciation on capital expenditures, and again Vattenfall has prepared a detailed projection of capital expenditure for budgeting purposes during the ordinary course of business, and Mr. Kaczmarek again has relied on those calculations when he's made his calculations. I should also add that the depreciation costs have been scrutinized by some of claimant's experts in this arbitration, namely Mr. Charles, Mr. Boke, and Dr. Blesich. The third largest, or in fact the second largest cost item is decommissioning. As I said, the way it works is that the actual expenses, cash flows are incurred once the plant is shut down and is being decommissioned, but the costs are recognized in the books during the operating life of the plant. The number here we're using includes only those decommissioning costs that are recognized during the operative years. And again, Vattenfall has, of course, has been required to prepare decommissioning cash flow projections as part of its business. And that's again what Mr. Kaczmarek has used in his calculations. So if we sum up the total costs, we get 11.5 billion, which results in an undiscounted net income of 2.22 billion. To arrive then at the positive cash flow from the operations, non-cash costs, non-cash items such as depreciation and provisions are added back to the net income, which leads then to positive cash flow of 3.97 billion. Then we have to add negative cash flows from decommissioning. During the course of 60 years, the total amount undiscounted is, as I said, almost 5, to be exact, 4.8 billion euro. And when you apply the discount rate to this, you get eventually the value of the plant in the but-for scenario, which is 1.469 billion euro that you see at the bottom of this slide. Now, as far as the discount rate is concerned, Mr. Kaczmarek has used, as is customary nowadays, the WACC, the weighted average cost of capital, and he has determined that the relevant discount rate here is 6.52%. So that's how we get to the but-for value of the Krümmel plant. If we move on then to the actual scenario for the Krümmel plant, well, of course, here the Krümmel plant has been immediately and permanently shut down. It's unable to restart and generate any positive cash flow, so the value in this scenario is simply equal to the present value of the future decommissioning cash outflows. And that's a big number, as you can see. And as I mentioned before, Vattenfall has prepared detailed projections of decommissioning costs for financial reporting purposes, as usual, scrutinized by auditors and by independent third-party experts. And Mr. Kaczmarek has used those in his calculations. So applying then to the decommissioning cash flows, again the relevant discount rate, which is 6.52, we get a total value of 1.639 billion euro. And if you add that to the but-for number, total diminution in value, so to speak, is 3.108 billion euro. Now, in relation to Krümmel, in the actual scenario, it should also be mentioned that the plant is left with 88 terawatt-hours of stranded old volumes, which we'll come back to. 88 terawatt-hours of OEPV. And of course, any money that can be generated by commercializing these volumes can be used to offset claimants' damages. However, as Mr. Kaczmarek explains more in detail in his reports, there is essentially no market for OEPVs in the actual scenario, in particular since the supply will be significantly greater than the demand. And this is, we say, a natural, as has been described today, this is a natural consequence of the decisions taken within the framework of the 13th Amendment. So Mr. Kaczmarek concludes that the OEPVs are worth 0 today. That notwithstanding, claimants are prepared to issue with respect to the OPVs an irrevocable offer for Germany to sign a trustee to try to sell the OPV and turn over any proceeds to Germany. If I move on then to the second plant that we're going to look at, namely the Bruckdorf plant. And here the methodology is more or less, well, is the same as we used with respect to Krümmel. There are some differences. The Bruckdorf plant had a higher, or has a higher output and utilization rate than Krümmel, as you can see. 1.4 megawatt hour, 89% utilization rate, so on and so forth. It has somewhat higher costs to operate the plant, 12.3 billion, and somewhat higher negative cash flows from decommissioning. But using the same methodology here in the but-for scenario, we get a value of 2.1 billion. In the actual scenario, Bruckdorf is still operating. Compared to the but-for situation, there are three differences to be noted here in the actual scenario. First of all, Bruckdorf has lost the new production volumes, the NEPVs. There is a fixed shutdown date, which is 2021, and Bruckdorf is paying the nuclear fuel tax. As far as the NEPVs are concerned, it's worth noting also that when the 13th Amendment was adopted, the plant had a total volume of 237 terawatt hours. Of those, 146 were NEPVs. That means that when the NEPVs, the new volumes, were revoked, Bruckdorf lost more than 60% of its available volumes. And already that, we say, indicate a quite substantial loss. The nuclear fuel tax that Bruckdorf is paid during the period of 2011-2016 and is part of the fuel costs for that plant. I should also note that even though 2021 is the fixed end date for that plant, the calculations show that it would probably have ceased operation in 2019 when they run out of production volumes. As a result of decreased revenues and a nuclear fuel tax, accelerated decommissioning costs, the actual value of the Bruckdorf plant in our calculations is 345 million euro.
So, can you help me here? So you just said that Bruckdorf will run out of its production volumes in 2019. Could it then not buy the production volumes from, what is it, the other one, Krümmel? That you say that they are unsaleable?
They are indeed, well, yes, that is a possibility, I suppose. I'm not quite sure right now how that has been factored in by Mr. Kazmarek in his calculation, so I think we'll have to consult with him to come up with an answer. Yeah.
I asked a question on your own case. It's not something I invented.
I do appreciate that. If I may then go on to the third plant that we're talking about here, the Brunsbüttel plant. And again, we start with the but-for scenario. But before we do that, there is a major difference between this plant and the two other plants, in the sense that here we're not actually valuing the plant as such, but the remaining production volumes of the Brunsbüttel plant. On this point, Mr. Kaczmarek and Ms. Hardin, Germany's expert, seem to be in agreement, i.e. that it would have been more economical for this plant actually to sell the volumes rather than trying to start up the plant and use the volumes themselves. So that is why we're using a different, well, the valuation method is the same in the sense that we're using the but-for and the actual scenario, but we're not looking at the plant. So if we start then with the but-for scenario with respect to the Brunsbüttel plant volumes. In the but-for scenario, the Brunsbüttel plant would have had 11 terawatt-hours of old volumes and 41 terawatt-hours of new volumes, i.e. a total of 52 volumes. 52 terawatt-hours, sorry. As Mr. Kaczmarek has explained in his report, there would have been a ready demand for these production volumes. There were no hard shutdown dates for any plants in the but-for scenario. The plants could continue operating as long as they had production volumes, and they would have had an incentive to continue to operate, since it would have obviously increased revenues and deferred the commission costs. Mr. Kaczmarek's analysis also shows that there would have been limited supply. The Brunsbüttel volumes would in all likelihood have been the only volumes available for purchase in the but-for scenario. So many potential buyers and one seller. This is very different from the situation that exists today, as a matter of fact, for the Brunsbüttel volumes, where there are many sellers but only few buyers. Now, to value these volumes, Mr. Kaczmarek has first forecasted the time at which other plants would have needed to purchase additional volumes. The forecast projects each plant's future electricity production based on historic average utilization. Mr. Kaczmarek has concluded that 4 plants would have had a demand to use the volumes during the period 2020 to 22. These 4 plants are Isar 1, Felixburg 1, Neckar-Westheim 1, and Unterweser. In this scenario, since there is really no uncertainty as to whether the volumes could be utilized, the plants would be willing to buy these volumes already in 2011. That's the basis for Mr. Kaczmarek's calculation. Bought in 2011 to be used in 2020 to 22. In determining the price that Brunsbüttel could achieve from the sales, there are no relevant historical transactions to compare to. So Mr. Kaczmarek has relied on a discounted cash flow method, as would buyers do, buyers of volumes do to assess how much they would be willing to pay. No specific data of buying plants has been available, so Mr. Kaczmarek has used the Krümmel and the Bruckdorf plants as proxies and applied an average of the values from the 2 plants. So that's the methodology that he has used to try to calculate the but-for value of the volumes in this scenario. When it comes to the price, then his conclusion is that for the old volumes, they could have been sold at 31 euro per megawatt hour, and the new volumes at 19.8 euro per megawatt hour. Results in undiscounted revenues of 1.63 billion. And using the discount rate again, 6.52%, we end up with 841 million euro in the but-for scenario. In the actual scenario, Brunsbüttel's license, of course, has been revoked. But just as in the but-for scenario, the valuation is made not of the plant as an operating asset, but of the plant's production volumes. In the actual scenario, Brunsbüttel has been deprived of its new volumes. This was 41 terawatt hours of the plant's total of 52. This is a revocation of 79% of the volumes. Again, already that a considerable loss. However, in Mr. Kazmarek's calculations, there is no foreseeable market for the remaining 11 terawatt hours of old volumes. So his conclusion is in the actual scenario that the volumes are worth €0. No value at all to be attached to them. And it should perhaps be mentioned in this context that Germany's expert, Ms. Harden, agrees that the Brunsbüttel volumes were negatively affected by the measures. We get that from table 29 in her second report. We don't need to look at that now. And furthermore, when she applies historical utilization rates to calculate production of volumes, rather than the reference production volumes, the RPVs that were mentioned earlier today, when she uses historical utilization rates, she agrees, she comes to the conclusion as well that the Brunsbüttel volumes are worth 0 in the actual scenario. If you look at the table we have up there, which is table 40 from her second report. We will come back to this concept of reference production volumes and historical utilization rates when we listen to Mr. Kazmarek. So, in conclusion then, if we take a look at the next slide, we summarize the total diminution in value. And this, basically, so to speak, corresponds to our claims, but not quite, because there are some differences here. Between Brunsbüttel, with respect to Brunsbüttel, there is no difference. The amount you see on the slide is the amount that we're claiming. For Krümmel, the actually claimed amount is slightly lower than what you see on the slide, and that is because Mr. Kazmarek has made some adjustments for tax and for some salvage parts that the plant has been able to sell. For Brookdorf, of course, there is a considerable difference because we are claiming only for 20% corresponding to our share, or to the claimant's share in Brookdorf. So those are the calculations on which we rely in support of our claims for damages. I should also say at this stage perhaps a few words about the report that has been submitted by the respondent, i.e. the reports I should say, submitted by Ms. Hardin. We have asked Mr. Kazmarek to quantify the damages that claimants have suffered as a result of the measures. The outcome is what we've seen, what we talked about. He has applied an ex-ante fair market valuation method to calculate the damages. His calculation, of course, is based on our positive case, our positive legal case. In fact, he has also included in his report what we call switches in an Excel model, which make it possible for you to calculate alternative outcomes should you not agree with us 100%. That's all in his report. Germany, however, has not offered any ex-ante damages calculation to serve as an alternative to Mr. Kazmak's calculation. Germany has expressly noted that it did not ask its experts to perform a calculation of Vattenfall's alleged damages. They have asked its expert, Ms. Hardin, to perform a non-responsive so-called impact assessment. And they have been very careful to stress that such an impact assessment is different from a damages calculation. The idea seems to be that Germany wants Ms. Hardin to conclude that there has been no adverse financial impact, and then argue that there needs to be such an impact in order for there to be a breach of the ECT. We get that from the counter-memorial paragraph 441, where the respondent says, in case of the 13th Amendment, the analysis shows that the measures did not have an adverse financial impact on Vattenfall. Failing such impact, there cannot be a breach. We have submitted or explained now submissions that there is simply no support for that kind of an approach. And what is more, Germany has instructed Ms. Hardin to disregard basically all fundamental aspects of our positive case when she is making her calculation or assessment. She, in her second report, which you see on the slide, an excerpt from in section 723, she says that my analysis is based on the legal instructions that the claimant's interests were not expropriated, that the NFT is not subject to jurisdiction of the tribunal, that the revocation of the LTEs are not breaches of the ECT, and that the tribunal does not have jurisdiction over the claims of Krümmel and Brunsbüttel. So the question is, what is she actually doing?
You have 1 minute left.
Sorry?
You have 1 minute left.
Very good.
With that question.
She has been asked to make an assessment of the impact of our breach of breaches made, we say, by Germany. And in doing so, she is assuming away all the breaches. So one wonders what is left of her report. We say nothing. It's nothing that is very helpful to the tribunal. So that concludes our opening statement. Thank you.
I do have a question, if I may. Could you please go back to slide 98? And that's the slide about the prayers for relief.
Okay.
And you explained to us your principal claim, and you put them in the alternative, but your principal claim is that you claim for Krümmel and Brunsbüttel 100%.
Yes.
Correct? So could you help me, because you say that you base that on control. Could you, but if you would base it on shareholding, then you come in your first alternative claim, isn't it? Or your second, actually, depending where you look at it. Could you help me? Why is it that you rely on control rather than on shareholding? And I'll give you an example why I ask this question, a very simple one. If I have a 50% shareholding in a company, I get 50% of the available dividends, not 100%. Unless there's a special arrangement, if I have special types of shares. why is that different for in your submission? And maybe
I'm not
the
quite-
comparison with dividends is not appropriate. But
I
could
mean,
you
these
explain me why
alternate-
you make this distinction?
These alternative claims that we presented are in response to objections made by Germany. So in case you accept some of their jurisdictional objections, we have prepared alternative claims. But our primary claim, is that Krümmel, Brunsbüttel are claimants in their own rights. So they claim for 100% of the damages that they have been afflicted. And that's item number one. That's our primary claim. And Vattenfall Nuclear, being the 20% shareholder of Bruckdorf, is claiming for that share, so to speak.
It goes back actually to one of the first questions you had this morning about the shareholding and what's the investment. Right, but you may have then the situation that you get 100%, whereas, for example, for Brunsbüttel, whereas there's only a shareholding for 66.7% by Vattenfall Europe, and E.ON has the other shareholding.
Because the damages inflicted on Brunsbüttel, they are what they are. And since the ECT is structured in such a way that is based on control, as you well know, a local incorporated company but controlled by a non-local company is an investor under the treaty and thus a claimant. And that is in that capacity that Krümmel and Brunsbüttel are claimants here.
Yeah, but
so that has nothing to do with the shareholdings.
I can see that. Okay, you are good.
I'm sorry, don't you add that with respect to Krümmel and Brunsbüttel, you manage the plants? And that's your key, I think.
Okay. We are, I think, what is called in German a managing shareholder, plus that we have a power of attorney to represent.
So
I say that again, the shareholdings in our primary case, that they are irrelevant, we say, for the damages. The reason why we are using the percentages here is to present to you alternative claims should you agree with some of the jurisdiction objections made by the respondent.
As a point,
has that to do with because finally these plants could be considered a kind of tolling plants?
What?
Tolling plants.
No.
TOL and G. Because what you do is it is only a cost-sharing arrangement for these plants, isn't it?
Yes, but I'm not quite sure how that is relevant for...
But I'm still at loss here, and you have to help me, is that what might happen here is that you get 100% of the damages for Brunsbüttel, whereas E.ON go also after the government or the state and say, well, look, I have here still some, what is it, 33 point something in shares, and I also have damages.
that's the question I've got too. And on your approach, could E.ON make a claim for 100% of the damages to Brockdorf on the basis that they control it?
Could we start first with the Krümmel plant and then, with the Brunsbüttel plant and then Brockdorf? With Brockdorf, you're claiming only 20%. For Brockdorf, you're claiming only 20%. Is that correct? Yeah. Okay, but there the problem is.
Well, it's not, because the question is whether the approaches between Brockdorf and the other two are consistent, or whether you're adopting different approaches to the different plants.
Well, we are clearly adopting, since the claims are different. Maybe I'm misunderstanding your question, but Krümmel and Brunsbüttel, they are as we say, claimants in their own rights, and in their own right, and so they are asking for, we are asking for the total damage, whatever that is, that they have been suffering.
But my question is still there, and I think it does go to the treatment of the other two. And if E.ON were non-German foreign controller, could it claim 100% of the damages to Brockdorf on your basis, even though they only own 80% of the shares?
Yeah, I mean, as a matter of principle, yes, I think so.
So if they could claim 100%, on what basis can you claim 20% now?
I mean, each claimant / investor under the ECT obviously has to prove their losses. And I mean, in so doing, there is no unbreakable link between shareholdings and the companies in question.
The answer, at least in part to this, is they are in this case because of a combination of Article 26(7) of the ECT and Article 25(2)(b) of the ICSID convention. So because by virtue of foreign control, which in those cases involves the operating control as the 50% holder, and the other case it's different, they get the whole bunch. They may have an obligation under applicable law to render, I mean, vis-a-vis E.ON, to render some of that to E.ON. That's your structure, I think.
Yes, and I think, I mean, we're getting perhaps into, I don't know, theoretical discussion here, but I mean, the ECT doesn't really solve these issues, and we can say this is bad or not, but I mean, you will not find the answer the way, I mean, you're putting the question, Mr. Chairman, to your, I mean, the answer is not to be found in the ECT. I think the ECT, you know, we must use it, you and we must use it as a treaty interpreted under the Vienna Convention, and it may well be that it does not have answers to all the questions. And I think one of the answers you will not find in the ECT is how to deal with shareholdings.
I see your point, because what you were saying is claimants 4 and 5, if I may call it that way, claim in their own right, because in your submission they fall under the treaty. Okay. But
we have made quite substantial submissions on that, and I mean, as you know, I mean, Professor Schroyer has explained that in his opinions, that the combination of, I think it's 26(7) of the ECT and Article 25(b) 2(b) of the ICSID Convention gives this result.
The question that still remains is that whether you can also that translate into damages in quantum. Okay, but let's put that for I will almost say another day, but that is not the case. It's another afternoon. Let's have lunch now, I would suggest. And can we reconvene? How much time do you need for lunch, Dr. Conrad and your team?
I think on my part, I would say so long as the aircon will take to be shut off, because otherwise I will be freezing. But an hour should be absolutely fine.
Shall we?
If we are faster, we can.
No, let's have a fixed time, 3:30. Okay.
By the way, we have now received Professor Dolce's CV, so we will transfer that to.
Okay, and also the information of Mr. Kasmarek about his Excel sheet.
You said after lunch? And
I said after lunch, but...
I'm sorry, yeah, and that's a bit of a housekeeping matter, I forgot. If we can go to slide 107 of Clayman's presentation, and bear in mind the figures you've just seen on 98, which has been on the screen. 107 shows that the figures are already different. And I believe Professor Hobert said he relied on the corrected calculations of Mr. Kaczmarek. That's ample proof that those calculations are already in existence. We asked for them yesterday after they were offered. We didn't get them. This morning they wanted to defer until Tuesday, then until lunchtime. Now they say after lunch. I think we have a pattern here.
No, Dr. Conrad, my order was after lunch. But I thought I could grab here the opportunity, hearing that also the CV of Professor Dotso is here, that we also may have more information on Mr. Kaczmarek. But that's not the case. So right after lunch at 3:30 we have the answer.